Judgment in the appeal case, the Scottish Criminal Cases Review Commission.
Lord Reid will explain the decision of the court.
If a person is convicted of a criminal offence, he can appeal against his conviction. But if his appeal is refused, that is normally an end of a matter. However, as a safeguard against potential miscarriages of justice, it is possible for a case to be referred back to the appeal court by the Criminal Cases Review Commission in England and Wales and by the Scottish Criminal Cases Review Commission in Scotland. The statutory ground for referral requires the Scottish Commission to be satisfied that a referral would be in the interests of justice. This appeal concerns a decision taken by the Scottish Commission refusing to refer back to the appeal court the appellant's conviction for rape, on the basis that a referral would not be in the interests of justice. In 2001, the appellant had sexual intercourse with a woman who then reported to the police that she had been raped. The appellant was interviewed by the police, and in accordance with the law, as it was understood at the time, he was not offered the option to consult a solicitor before the interview, and no solicitor was present during it. During the interview, he admitted having had sexual intercourse with the complainer, but maintained that it had been consensual. As a result of his admission, semen which had been found on vaginal swabs taken from the complainer was not subjected to DNA analysis. At the trial, the prosecution relied on the interview as evidence that sexual intercourse had taken place, providing the necessary corroboration of the evidence given by the complainer. The appellant also relied on the interview as setting out his defence of consent and did not give evidence at the trial. The appellant was convicted by the jury and sentenced to 5 years' imprisonment. The appellant appealed against his conviction unsuccessfully. His case was later referred back to the appeal court by the Commission, again without success. The appellant then applied to the Commission for his case to be referred back for a second time, relying in part on the decision of this court in the case of Cadder and Her Majesty's Advocate, where it was decided that Article 6 of the European Convention on Human Rights required suspects to be permitted access to legal advice prior to and during interrogation by the police. His argument, put shortly, was that the admission he made at interview that he had sex with the complainer had been an essential part of the prosecution case, but it had been obtained in breach of his human rights. It ought to have been excluded from evidence at the trial, applying the law as later decided in Cadder, in which event he could not have been convicted. The Commission declined to make a reference. Although the interview had not been conducted in the manner later held in the Cadder case to be required by human rights law, nevertheless, the Commission did not believe that it was in the interests of justice that a reference should be made. In reaching that conclusion, it referred to the time that had passed since the conviction, the fact that the appellant did not dispute that the admission he made during the interview was true, the fact that he had never disputed that the police had conducted the interview fairly and that the prosecution had used it fairly at his trial, and the fact that he himself had relied on the interview at the trial. The appellant applied for judicial review of the Commission's decision. That application was refused by the Scottish courts, and the appellant now appeals to the Supreme Court. He argues that the Commission erred in law in taking into account the fact that he did not dispute the truth of his admission at interview that he had had sex with the complainer, and also in taking into account that he did not dispute the fairness of the conduct of the interview or of the way in which it had been used at the trial, and also in taking into account that he had relied on the interview at his trial. The Supreme Court unanimously dismisses the appeal and holds that the Commission did not err in law in any of the ways suggested. It was right to take into account the fact that the appellant had not disputed the veracity of what he had told the police in the interview. The fact that the evidence in question was and remains undisputed is plainly relevant to whether it is in the interests of justice to make a reference. It would not normally be in the interests of justice to quash a conviction merely because, under the law as now understood, there was a lack of admissible corroboration of a fact which was never in dispute and is admittedly true. The court also notes that it was because of the answers given at interview and the admissibility of those answers under the law as understood at the time that the semen found on the swabs was not submitted to examination so as potentially to provide other corroborative evidence. The Commission was also correct to take into account that the appellant had not challenged the fairness of the behaviour of the police during the interview or its use at the trial. Prior to the Cadder decision, there were well-established grounds of objection on which the appellant could have relied in the event of unfairness in the conduct of the interview or the use made of it at the trial, and his failure to do so was plainly relevant to where the interests of justice lay. It was also a relevant consideration that the appellant had himself relied on the interview in order to present his defence to the jury. Indeed, the result of placing the interview before the jury was that the appellant did not have to give evidence in order for his defence to be before the jury and could therefore avoid exposing his defence to cross-examination. He took that opportunity, which would not have existed if the interview had been inadmissible. For all those reasons, the appeal is dismissed.